ta giải quyết tranh chấp tại các cái thủ tục như là hòa giải hoặc trọng tài thì phải có những cái kỹ năng và kinh nghiệm cần thiết. Khi chúng tôi nhận được cái đề xuất phối hợp và cái ý tưởng của sự kiện tổ chức tranh chấp nội bộ của công ty luật VIAC và công ty luật D. Brown, thì chúng tôi tin tưởng rằng cả Trung tâm Trọng tài Quốc tế Việt Nam và PCA là Tòa án Trọng tài Thường trực đều rất là hoan nghênh cái tinh thần tích cực trao đổi kiến thức nghề luật của các công ty có uy tín tại Việt Nam và Singapore, và do đó chúng ta đã có sự kiện ngày hôm nay. Tuy nhiên thì cũng là một cái tổ chức trọng tài độc lập và thực hiện cái điều phối quản lý các cái thủ tục tố tụng trọng tài, thì cả Trung tâm Trọng tài Quốc tế Việt Nam và PCA đều nhận thức được cái tầm quan trọng của việc đảm bảo một cái vị trí trung lập của chúng tôi trong việc tuân thủ các cái nguyên tắc để bảo vệ cái sự trung lập đó. Do vậy chúng tôi cũng mong là tất cả các diễn giả là sẽ tránh đưa ra các cái ví dụ viện dẫn tới các cái vụ tranh chấp cụ thể đang được diễn ra tại VIAC cũng như là tại PCA, để chúng ta thực sự tuân thủ tuyệt đối cái nguyên tắc nêu trên cũng như là cái nguyên tắc hành nghề của các cái luật sư. Và một lần nữa thì thay mặt Trung tâm Trọng tài Quốc tế Việt Nam, chúng tôi xin trân trọng cảm ơn tất cả các quý vị đại biểu, các diễn giả đã dành thời gian tham gia và chia sẻ tại cái hội thảo ngày hôm nay. Chúng tôi hy vọng rằng những cái thông tin được chia sẻ tại hội thảo ngày hôm nay thực sự là sẽ có hữu ích cho cái hoạt động nghề nghiệp của quý vị. Xin kính chúc quý vị sức khỏe và thành công. Xin trân trọng cảm ơn.
Xin được cảm ơn chia sẻ của ông Ngô Thanh Tùng cũng như là chia sẻ của ông Vũ Ánh Dương. Sau đây để mở đầu cho cuộc hội thảo ngày hôm nay, tôi xin phép được giới thiệu bà Lê Thị Thương sẽ trình bày về các loại tranh chấp thường gặp trong các giao dịch M&A, cụ thể là các hợp đồng mua bán cổ phần và phần vốn góp. Bà Thương tốt nghiệp thạc sĩ tại Đức, hiện nay đang là một Senior Associate, chuyên viên tư vấn cao cấp tại công ty luật VIAC. Bà Thương được đào tạo chuyên sâu về trọng tài và là một trong số ít người Việt Nam được đào tạo về trọng tài quốc tế tại Viện Trọng tài Paris ở Pháp và Viện Pháp luật Quốc tế La Hay, Hà Lan. Bà Thương đã tham gia với tư cách luật sư tư vấn trong rất nhiều vụ việc trọng tài, cả trọng tài đầu tư cũng như là trọng tài thương mại quốc tế trong nước và ngoài nước. Và trước khi làm việc tại VIAC, bà Thương đã có một thời gian làm việc tại Trung tâm Trọng tài Quốc tế châu Á AIAC tại Kuala Lumpur, Malaysia. Sau đây xin trân trọng kính mời bà Lê Thị Thương ạ.
Good afternoon, ladies and gentlemen. I'm very happy for having me today to share a little bit of my knowledge in the field of M&A dispute resolution. And within the scope of this workshop this afternoon, so I will focus my presentations on the common dispute in M&A deals. So, okay, so the agenda of my presentation will go through. First, we will go through some introductions of Vietnam M&A landscape, and then we will examine the different stage of an M&A deals transaction. Afterward, in this stage, we will examine the potential and possible dispute that may arise from an M&A transaction. And then we will examine a case studies that involve Vietnamese party. And in the age of this pandemic, we will see how the M&A dispute have emerged and what are the new trends development of this kind of dispute. And I will conclude my presentation with some remark. So as introduced by my colleague, so we may see that Vietnam in the past decade, Vietnam has witnessed a strong M&A development, and according to the Oil Monitor M&A Investment Index, the country ranked the second on a list of world's most active, dynamic, and potential markets for M&A for the periods from 2015 to 2021. So we may see from the graph on the screen, we can see that the numbers of the M&A transaction in Vietnam has developed, had increased in the past decade from barely some deal in the early 2000s until to 651 deals in 2021. And the M&A activities in Vietnam is not increased and growth with respect to the numbers of the deal, but also in the size of the transaction. And even amidst the COVID pandemic, we still witnessed an increase in the average deal size of M&A transaction in Vietnam, which is reported in KPMG statistic. So in parallel with the strong development of the M&A transaction, we also, which bring about the opportunities, but also the challenge, especially the risk of dispute, which is increased steadily in the era of the pandemic, particularly. According to a report of FTI Consulting, the number of M&A disputes referred to arbitration for settlement worldwide grew steadily at more than 3% a year from 2010 to 2019 and increased almost 10% in 2020. And the report of the Singapore International Arbitration Center in Singapore also indicate that in the first year of the COVID outbreak, the number of the corporate dispute administered by these centers amount to 29% and make it the most popular dispute center. And we also do some kind of research regarding the case of corporate dispute that administered by Vietnam International Arbitrator. Then there were 35 case M&A dispute referred to arbitration under the auspice of VIAC for settlement. So what dispute may arise from M&A transaction? So now let's look at the phases of the M&A transaction. So just dive. There will be 5 standard phase in an M&A transaction. The first phase is the initial negotiation between the party. The second one is when the party could reach a term sheet or maybe or letter of intent. And then the third will be the due diligence phase. The fourth is the phase where the party negotiate and execute the sale and purchase agreement, and then proceeds to the last phase, that is the step leading to closing. So at the first phase of the M&A transaction, which called initial negotiation. So in this phase, generally, the buyer will be provided with some basic data and information regarding the target company, the seller. And in this phase, the party may execute a confidential agreement with each other. And if it's expected that the deal will be fruitful, the party may execute the exclusivity agreement. So after the negotiation successful, then if the seller identified the buyer that they may proceed with the deal, then the party will proceed to signing the term sheet or letter of intent. So in the term sheet, it will describe the key term and condition, or if the party haven't concluded any confidentiality agreement or exclusivity agreement in this term sheet, the party may also include and provide for these provisions. And then in the due diligence, in the due diligence phase, the buyer will be provided with more information related to the target company. And this is through the investigation of the target company. Then the buyer will also be able to identify the condition that's required for the deal to be concluded, and what are the representation and warranties that the seller have to make. And after the due diligence, if the buyer satisfied with the outcome of the due diligence, the buyer and the seller will proceed to negotiate and conclude the sale purchase agreement. Afterward, the party will move forward to perform the step leading to the closing. And if every step is complete and fulfilled, then it will lead to the post-closing. So at each stage of the M&A transaction, the dispute may arise. After the party conclude the confidentiality agreement or exclusivity agreement, or maybe in some transaction, the seller will require the buyer to make some kind of deposits. So after the first phase, when the party conclude those kind of agreement, the dispute may already arise at any phase. Okay, so now let's look closer to the potential dispute of the M&A transaction. So usually the M&A dispute will fall into two categories. The first one is the pre-closing dispute, and the second one is the post-closing dispute. For the pre-closing dispute, it may include the pre-signing dispute, and those disputes arise from post-signing to pre-closing. So for the pre-signing dispute, it's maybe the dispute that arise from the ancillary agreement that I mentioned earlier. That's the exclusivity agreement, or confidentiality agreement, or deposit agreement. And with respect to the dispute that may arise from the post-signing to the pre-closing, so it may related to the failure to obtain authorization. So one of the most common provisions under any sale and purchase agreement and M&A transaction, that's the commitment to obtain the required approval and authorization for the deal to be closed, legally closed. For example, like merger filing, or any kind of approval that is required for the foreign investor to hold any kind of share in the company in a specific industry. Another dispute that is the breach of other covenants and condition. For example, for the seller, for the buyer side, so in a loss of deal, that the buyer have to commit about their ability to arrange finance, arrange loan or finance for the deal. So it's required under the agreement that they have to provide some kind of like bank, some kind of letter of credit, or the commitment by the bank to finance the deal. And for the seller side, in some case, it will be required that they have to restructure the organization of the company. For example, they have to divide the company, the business sectors of the company, so that it allow the foreign investor to hold like 49% or 50% of the share of the company, and they have to fulfill those obligations at some point of time as agreed under the agreement. Then the dispute may arise if whether the party have fulfilled the obligation, the covenant pre-closing. Another dispute that may arise, that's the dispute regarding to the material adverse change. So usually these provisions allow the buyer to walk away if there's occurrence of material adverse change or adverse effect that's caused detrimental to the business of the target company, which deprive the buyer of their expected outcome or the business of the business operations of the target company. And it's and another source of dispute which concerning the correctness of the representations and warranties made by the seller. So usually the buyers may claim for the price adjustment if it is discovered that there is some kind of representations and warranties that's not correct. For example, like the non-existence of any assets, or there is some kind of hidden liabilities that affect the evaluations of the price of the company. For the post-closing dispute, the post-closing dispute usually fall into five categories. The first one is the dispute concerning the applications of earn-out provision. So the earn-out provisions allow the buyer to receive some payment after closing based on their performance, the business performance of the target company. So usually the party may dispute about how the actual performance of the company should be measured, and the matrix performance to be used to make those kind of measurement. So if it's not clearly provided under the agreement, like in which business sector should the performance of the business to be measured, or what kind of accounting methodology to be used in measuring the performance of the company, or where the seller has operated the buyer has operated the company in an ordinary course, which prevent the earn out to occur. Another dispute that may arise post closing, that is the breach of the post closing covenant. So usually under the M&A sale and purchase agreement, the party may agree on non-solicitation or non-competitions or non-disclosures or use of the trade secret or the confidential information of the company. And the dispute may arise if either the party breach this agreement, the component, and so this dispute remind us that so in the dispute resolution it should in the M&A agreement, it should be clearly agree on the periods of time that these agreement and these covenant remain effective, and in which business sector should be applied. Another source of dispute for post-closing, that's the indemnification for breaches of the representation and warranties. So as we discussed earlier in the M&A agreement, usually the party will provide for some representation and warranties by the seller to the buyer, for example, like as to the financial conditions of the target company, the legal, the tax, and the compliance of the company. So if post-closing the buyer discover that there is any inaccuracy or incorrectness of the representation and warranties made by the seller, they may claim for the indemnification. However, it should be taken into account that depending on how the provisions the indemnification is defined under the M&A agreement, the buyer may claim for only the actual loss and damage, or they may claim for the overpricing due to the non-disclosed information or the hidden liability, or even for loss of profit. In post-closing, the party may also claim for other indemnification. especially like for the indemnification regarding to the covenant related to other ongoing problem that the body have already aware of, but for any reason they didn't provide it in the agreement. For example, like the ongoing legal cases. So who will bear the cost that array, the cost and expense incurred from the ongoing legal cases, or the cost and expense related to any third-party claim that related to the problem that already known by the party before the closing. And another major dispute category that may arise post-closing, that's the working capital purchase agreement. So the part in the M&A agreement, the party may agree to adjust the amount to be paid at closings based on the working capital of the target company that evaluated by the buyer. So if the working capital evaluated by the buyer at the closings is higher than those that evaluated by the buyer pre-closing, then the buyer have to make another payment to the buyer and vice versa. However, like in practice, the party may dispute about how working capital will be calculated, which accounting methodology to be used, and what to be included and excluded from the working capital. So in our course of practice, we have deal with a lot of cases in which the buyer claim for be more specific on this type dispute. I would like to refer to the case, a real case that released earlier this year. So that is the case between the global payment servers and UTC investment versus VMG Media. So this is the case that administered by SIA. So in 2017, GPB and UTC acquired 62.5% of the VNPTE pay from VMG for almost 23 million US dollar, which is 7 times the initial investment of the VMG Media. But then subsequently in 2018, VNPT e-pay was investigated by the Investing Police Agency in Phú Thọ Province over its alleged involvement in major online gambling ring, that leading to prosecutions against VNPT management officer for organizing gambling and illegal trading invoice. In November 2018, a criminal court in Phú Thọ Province also found that VNPT e-pay had raised funds invoice worth more than almost 29 million US dollar. So after discovered these information, GBS and UTCs refer to SIA for settlement for the claim. The first claim is that the VMG Media breached the warranties and for providing false information during the sale. And second, that VMG had not truthfully reflected the financial position of VNPT e-pay, which increased the purchase price. The purchase price. And at the end of this proceeding in SIA, the tribunal constituted under the auspice of SIA rendered VMG Media to compensate to pay GBS and UTCs an amount of almost 26 million US dollar. So now moving to the Now moving to examine how the M&A dispute have emerged, the new trend and development during the COVID in and post the COVID era. So given the effect of the COVID pandemic and the lockdown policy of the countries worldwide on people and the business worldwide, it have give rise to a number of trends with respect to the M&A dispute in and post-pandemic. So the first, so it concerning the applications of earn-out provision. So as we discussed earlier, earn-out provision allow the buyer to receive an amount of money after the post-closing based on their business performance. However, how to measure the business performance as the base for the earn-out provision. So the seller and the buyer may dispute over whether the company is operated post-closing in an ordinary course of business, and the party may try to renegotiate the term that already agreed under the agreement concerning the earn-out calculation. And this give rise to the dispute. So as to how to determine whether a company is operated in ordinary course of business, I will discuss earlier. So apart from the dispute surrounding the applications of earn-out provision, we also see a numbers of cases concerning the applications of the material adverse change or material adverse effect, and also whether the buyer breached the pre-closing covenant regarding the company will remain the business and operation in ordinary course of business. So with respect to the material adverse change, so as we discussed earlier, this provision allows the buyer to walk away from the deal if there is any event that detrimental to the business outcome that they may expect under the agreement. So whether COVID is considered a material adverse change. So there's no available case in Vietnam that's showing how material adverse change is determined and interpreted under Vietnamese law. So as well as we may know that there is no legal definition for material adverse change under Vietnamese law. But when we do some research and gone through the practice of applications of these provisions in the age of the pandemic, we see that the court and arbitrator worldwide, they will set out the principle to consider whether COVID should be considered as a material adverse change. So in this, they will consider whether, like, firstly, they will base on the provisions, the wording of the provisions under the agreement, that whether there is any case out of the exclusions of the kind of events such as the COVID pandemic under the material adverse change, and whether the durational significance of the change on the business, and third, that is the threat to the overall earning potential of the target company. Regarding the dispute concerning whether the company was operated in ordinary course, so in this dispute, the party tried to attempt to make some benchmark in evaluating whether the company is already operated in ordinary course. So whether it should be based on the historical practice of the company, or it should based on the industry spark in the area in the periods of the pandemic. So same as for the material adverse change dispute. So in Vietnam, there is no public or available cases show how the court or arbitration in Vietnam examine whether a company already operate in ordinary course during the time of COVID. But like when we've gone through several cases worldwide, we see that it will be examined on case by case basis. That's a, for example, like for several cases in the US, that the court decide that the seller breached the covenant regarding the ordinary course of business, even though change was reasonable under their circumstances. And there are two other cases at ICC. So the ICC arbitrator determined that in two ICC cases, the arbitrator determined that the seller breached the covenant on operating in ordinary course of business, because it is not consistent with the cost of conduct during pre-pandemic, even though it's reasonable in time. So what we may learn from this kind of dispute, that is how to draft the M&A agreement. So we have experience like in our course of practice, we have deal with a lot of case, a lot of M&A agreement in which the provisions is ambiguously or vaguely provided. So given that, it will be really hard to defend even the seller or the buyer if the provisions are not clearly provided. So it is suggested that the provisions should be as much clear as possible, and also it is suggested that there should be an appropriate planning and sufficient forethought for executing this agreement. For example, during the due diligence phase, when the party may identify what kind of representation and guarantee that should be made by the party, and what the condition that should be fulfilled so that the deal may be closed. And for another issue, that is the dispute mechanism that to be chosen by the party for settling this kind of dispute. So in M&A transaction, there are cases that there's a package of transactional documents. So it would be necessary and important for these documents to provide for consistent dispute resolution mechanism. We have dealt with a number of cases in which the dispute resolution under related transactional documents are inconsistent. So given the inconsistency between these documents, it's very hard for the party to consolidate the related claim in one proceeding. And that in principle, where the party have agreed for arbitration, they have to wait for that dispute to be settled at arbitration, and then afterward they have referred to the other court for the other proceeding to settle the other issue. So this will prolong the proceeding and the cost and the span of the legal action to be taken by the party. So thank you very much for your listening.
Xin cảm ơn phần trình bày vừa rồi của bà Thương. Tiếp theo đây, tôi xin mời ông Tom Ambell sẽ đến chia sẻ. Luật sư đến từ công ty luật The Brown sẽ chia sẻ với các bạn, với các quý vị, về các phương thức giải quyết tranh chấp đối với các tranh chấp phát sinh từ các hợp đồng mua bán cổ phần đóng góp cũng như là các thỏa thuận cổ đông. The Brown là một hãng luật hàng đầu của Hà Lan về giải quyết tranh chấp bằng trọng tài, và đặc biệt ông Tom thường xuyên tham gia những cái vụ việc giải quyết tranh chấp bằng trọng tài trong nhiều lĩnh vực khác nhau như năng lượng, xây dựng, công nghệ cũng như dịch vụ tài chính. Sau đây xin mời ông Tom với những chia sẻ của mình ạ.
It's just working perfect. Good afternoon, everyone. It's a great pleasure to be here and to be able to present to you. I want to thank everyone who joined us here in Hanoi offline, but as well as the people that are watching online for participating in this event. It's a great pleasure to be presenting with our good friends of VIAC, and the PCA. So thank you very much. My name is Tom Abon. I'm a senior associate with De Brouw in our international arbitration practice, and I'm here together with Albert Marsman, who's our partner in the Singapore offices, and we are focused on disputes in our Singapore office. Albert will talk about, will take part in the panel session later, and I will give you this presentation, this brief introduction, because we only have 20 minutes on available forums for the resolution of corporate disputes. So let's get started. I'll run you through the agenda. Thank you. Yeah, we'll start first with a brief introduction on why you would choose arbitration for corporate disputes. Why is arbitration a good mechanism to solve these disputes? And then we'll discuss some key considerations for you to take into account when you're arbitrating or when you're deciding to arbitrate a corporate dispute. And we'll round off as a third topic to talk a bit about investor-state arbitration. So let's start off with the first topic of today, which is why should you pick arbitration for corporate disputes? To give you an idea, and Vilaf already provided a lot of input on what a corporate dispute is. We listed some examples of some other disputes in addition to what Vilaf discussed. You can think, for example, of post-M&A disputes, both post and pre-closing. I think Vilaf already explained a lot about it. For example, purchase price adjustments, inadequate disclosures, material adverse changes after the deal closed. And then, as an example from our practice, we were involved in a deal with a European seller and an Asian buyer. It's a concluded case, so I can talk about it. And between signing and closing, the buyer alleged that the target's financials were disappointing, and the buyer wanted to amend or terminate the transaction. Of course, the seller wanted to continue with the sale on the terms that were agreed in the SPA. And the question in the arbitration thus was, can the buyer get out of the deal? Can they terminate it and walk away? Eventually, the tribunal decided in favor of the seller, which was obviously good for our client, and found that the alleged deterioration of the target's performance was no excuse to get out of the deal. Similar types of disputes were seen during COVID, as my colleague already alluded to, with buyers invoking the MAC clause and other provisions to get out of the contract and to terminate the deal. Some other examples are joint venture disputes, which are slightly different from M&A disputes, and they can, for example, deal with contributions of each partner to the joint venture, mismanagement of the joint venture, disputes about decision-making in the joint venture, who holds a deciding vote for what kind of topics, exclusivity, non-competition. As a partner, can you compete with the joint venture in similar markets? Is there a certain region that you're assigned to? And buyout and exit conflicts. I think the last is interesting. Another example from our practice, also of a case that is concluded, involved a joint venture partner in Asia, and it concerned the buyout indeed of the joint venture shares. And the key of that dispute was, what is the valuation date that has to be used for valuing the shares for the buyout? And it was crucial because we argued for a valuation date prior to COVID, and the other party argued for a valuation date after COVID. So that had obviously a huge impact on the value of the business. So these are prime examples of joint venture disputes that could go to arbitration. So now that we've given you some flavor of what corporate disputes are, we would like to organize a brief poll with the audience, both offline and online, to have your views. The question is, at the start of every corporate relationship, of course, you don't want to think of potential disputes, but it is wise to do so, as hopefully you'll walk away from after this seminar. And our question to you is, once a conflict is inevitable, what is the best way to address it? Now, we've put a QR code on the screen. I don't know if that works from the audience. It does? Okay. You can use the QR code, or you can use the website debrouvote.com and then type in the code Vietnam. If you use the QR code, you go there instantly. And you'll each have 2 votes to vote for your preferred way to deal with corporate disputes. You can use the 2 votes for one type of mechanism, or you can use it for 2 different mechanisms. And the choices are negotiation, mediation, arbitration, litigation, or any other form. So I got the results here. Unfortunately, I can't show them on the screen, but I can see quite a lot of votes already coming in. I don't want to rig the results, but arbitration is winning. Negotiation is a close second. We have one litigation, 2 litigation actually. I'll wait a bit longer. Our negotiation is catching up. Okay, I'll tell you the interim scores. It's 52 votes for arbitration and 45 for negotiation, 46 now. And then followed by mediation, far behind with 20 votes. And then 5 votes for litigation. And there's 1 person who voted other. Very interested to hear what the other option, what the person thought, but I'm not sure if that one is in the audience, that person. So arbitration preferred, closely followed by negotiation. And that is closely aligned to another poll that was held by the Singapore Institute International Dispute Resolution Academy. Because they found that practitioners and counsel gave the following results. They had a preference for arbitration, a strong preference for 74% of respondents voted for arbitration. Then litigation was 49%, and then mediation and hybrid dispute resolution option. So the hybrid dispute resolution option could indeed contain a negotiation as well. But again, arbitration was the preferred option there. So it's interesting to see that the Vietnamese audience has the same impression. And we'll follow up on that a bit when we talk about the arbitration trends in Vietnam later on. So why do corporate disputes often go to arbitration? Why is arbitration interesting for these kind of disputes that we just discussed? First and foremost, in corporate disputes, parties are often from 2 different countries. And by many parties, it is seen as unfair if they have to litigate in the home courts of their counterparty. Hence, parties go to choose international contracts like the M&A contracts. They typically choose arbitration in a third country because it provides for a neutral forum and is not related to a particular jurisdiction. Second, if the counterparty does not comply with the outcome of the arbitration, you want to be able to enforce the award, including in the country where your counterparty is located. The big advantage of arbitration in this respect is that global enforcement of awards is very straightforward via the New York Convention, which is widely accepted in 169 countries. And there's no similar counterpart to such convention in litigation. So main upside from arbitration is the easy enforcement and recognition. Third, these types of M&A deals often are highly sensitive and PR sensitive. So confidentiality in arbitration can be very important for companies. The matters are also often highly technical. So the proceedings may benefit from arbitrators that are well versed in M&A transactions or a particular line of business. For example, if you have an oil and gas M&A deal, you want preferably an arbitrator that has experience in the industry and knows the ins and outs. And with arbitration, you can select your arbitrator, of course. Finally, slightly more sobering note, in smaller cases, arbitration might not be suitable because of the fact that, unlike litigation, the parties will pay the cost of the arbitrators one-on-one. So it can be expensive. And litigation might be a better option for the smaller disputes, although we'll get back to this slightly later to nuance this a little bit. If you decide to opt for arbitration, there are a number of key items you need to consider when making that choice. The first and the most important one is the seat of the arbitration. It's because the local courts at the seat, they play an important role in the arbitration. First, the losing party can apply to the courts of the seat to have the award set aside. For example, when the right to be heard is allegedly breached. Second, the court at the seat may be permitted to intervene if interim measures during the arbitration are requested, such as an asset freeze or an attachment of assets. And third, if there are problems with the constitution of the tribunal, these may sometimes be heard by the court of the seat, and they might eventually appoint arbitrators. In view of these elements, it's essential that the seat is in a jurisdiction where the courts can be trusted and are independent and neutral. As you can see, these are some of the seats that are frequently chosen globally in arbitration. And within Asia, Singapore is often and increasingly chosen because of some elements that we'll discuss in our next slide. It's actually the most popular seat in the region. Also, you see a trend of increased popularity of arbitration in the larger Asia region, with other seats in Asia also increasingly being selected. The reason that Singapore is considered as one of the most popular seats for arbitration in Asia is that Singapore courts are deemed independent and objective. Additionally, the courts have adopted a relatively hands-off approach to arbitration. For example, the grounds to set an award aside by the courts are very limited. The public policy exception is interpreted restrictively. So the courts have a very hands-off approach and generally will not go into the substance of the award. And are very restrictively applying the public policy exception. And in terms of enforcement, Singapore is also part of the New York Convention, so enforcement is straightforward in a lot of jurisdictions. Turning our attention to Vietnam. In Vietnam, arbitration is also becoming increasingly popular. And indeed, Vietnam is also a party to the New York Convention. And arbitral awards issued in Vietnam are also enforceable in a lot of the other countries in the world that are a party to the convention. It's very favorable. Additionally, the Vietnam state authorities have taken several initiatives to promote arbitration. For example, the Civil Procedure Code was amended in 2015 with more arbitration-friendly provisions. And on top of that, the Supreme Court is drafting a resolution to ensure consistency in the application and interpretation of the New York Convention by the lower courts, which should make arbitration even more of a better option in Vietnam. These efforts are paying off because the percentage of arbitral awards that are refused recognition and enforcement in Vietnam, although it's fluctuating, has generally decreased over time. So just one back. Yeah, so closely related to picking the right seat, our second consideration relates to how one can negotiate a preferred seat when you're negotiating the arbitration clause, for example, in your contract with a counterparty. And it's important to know in this context that in arbitration of corporate disputes, the governing law does not always play a decisive role. Frequently disputes, and especially in corporate disputes, they are contractual in nature, and in practice, tribunals consider both the text of the contract and other circumstances, such as negotiation history, regardless of the contract, the governing law. So, of course, there's other cases where the governing law is very important, very particular cases. But in general, when it concerns the application of contract law, the governing law is less important. On the other side, as we discussed previously, the seat is key to ensure that arbitration is conducted independently. Therefore, in a negotiation on an arbitration agreement, a favorable seat can sometimes be traded against the governing law. As long as you get the seat that you want, you might consider giving away the governing law. The third key item is picking the right institution in the arbitration agreement that will administer the dispute. On the slide, we put the logos of some of the reputable institutions in the region. So we have the Vietnam International Arbitration Center, the PCA, the Singapore International Arbitration Center, and the ICC, which are the main institutions in the region. And we'll briefly, if the slide wants to work, we'll briefly discuss the main features and draws of each of these institutes, starting with the ICC. The ICC is world leading in terms of volume and size of cases. And unlike other institutional rules, the ICC rules require that the tribunal adopts terms of reference at the beginning of the arbitral proceedings. Now, these terms of reference are determined, they define the scope of the dispute so that it doesn't branch out. So it's structured around the topics that are included in these terms of reference. That can bring order, but at the same time, it can also complicate matters where parties cannot agree on the terms of reference. So it can increase the time it costs, and it can increase the cost of the arbitration as well. Further, the ICC rules provide for ICC courts to scrutinize awards before they are finalized and executed by the arbitrators. Scrutiny ensures a high standard of quality, which limits recognition issues later on. Moving on to SIAC, arbitrations are generally conducted expeditiously. For example, the tribunal is expected to send the draft award to SIAC no later than 45 days after the tribunal declares the termination of the proceedings. The rules also include provisions for emergency arbitration, under which an arbitrator can be appointed within 1 day, and the arbitrator is expected to issue awards within 14 days of appointment. And we note that ICC arbitration also provides for emergency arbitration, but the ICC rules, the emergency arbitrator cannot issue an award, but only an order. So that becomes relevant when you want to enforce it through the New York Convention. Also, the SIAC rules allow for request for summary disposal of a claim, which is manifestly outside of the jurisdiction of the tribunal or without any merit. So in a nutshell, VIAC has rules, some clever rules, which can streamline proceedings. Then moving over to VIAC, also the rules of VIAC have some unique features. And a notable feature is a provision which is not often seen in arbitration rules, that the tribunal shall be required to conduct a mediation if the parties so request. And the provision, we think, corresponds with a global trend of increased interest in hybrid forms of dispute resolution that we see throughout the world. The mediation, if successful, is encapsulated in an award that is enforceable throughout the New York Convention. So this is a very interesting feature of the VIAC rules. In VIAC, the respondent must also file its response, the statement of defense, within 30 days of the day of receipt for the request for arbitration, which is also very quick compared to other rules. Finally, a very interesting feature of the VIAC rules is that an award rendered by the VIAC tribunals do not require recognition by the Vietnamese courts, but may be presented directly to the Vietnamese enforcement agencies for enforcement. And it's a significant benefit for VIAC arbitration if you look for enforcement in Vietnam. Then to finalize with the PCA, it is one of the oldest and most experienced arbitral institutions in the world for the settlement of international disputes. It's focused particularly on international disputes involving states and state-like entities, but also handles private party disputes. In a PCA arbitration, parties can choose to apply the expedited arbitration regime offered under the UNCITRAL rules, where the tribunal has to issue an award within 6 months of its constitution. I'm sure that my colleague of the PCA, Mr. Nukop, will explain to you in more detail the PCA rules. So we'll leave it at that. Next. Yeah. So we mentioned before that arbitration is becoming increasingly popular in Vietnam and with Vietnamese users. And you can see that on the chart of top 10 foreign users at VIAC, both in 2019 and in 2021. And even though VIAC doesn't have an office in Vietnam, in Hanoi or Ho Chi Minh or anywhere else, the number of Vietnamese cases increased significantly. In 2019, there were only 17 cases with Vietnamese parties involved, and that grew to 55 cases in 2021, which is a significant increase. And Vietnam propelled itself to 6th position of VIAC foreign user rankings of 64 jurisdictions in total. Additionally, VIAC appointed several Vietnamese arbitrators in the last year. So also VIAC is very much aware of the growing interest in Vietnam in arbitration. And this also resonates with the numbers of VIAC, who administered 270 cases in 2021, of which 18% involved a certain foreign element. And that's up to 153 cases 5 years earlier. So this also reflects a significant increase in the caseload of VIAC. Additionally, the PCA is planning to open its office in Q4 in Hanoi to administer arbitrations and offer Vietnamese parties even more direct access to their renowned facilities. Then our fourth key consideration relates to the presiding arbitrator. In three-person tribunals, one of the arbitrators will be obviously the presiding arbitrator. And it's an important figure in a tribunal. They can decide, they hold a decisive vote in a significant number of cases where each party appointed co-arbitrator holds a different view, and then the president has the deciding vote which view he agrees with. So it's very important and key to ensure that you have the right person appointed as your president in a tribunal. So the parties may want to influence this decision and have some sort of control thereover. An example from our own practice is an agreement to apply the so-called list procedure, under which the parties are provided with a list of 5 names of candidate presidents by the institutions, from which they may strike, for example, 2 names that they do not favor. So only a maximum of 2 names. And then each party has a list of 3 names that remain, and the remaining candidates are listed in their order of preference. And then there's a number of common names, and the one with the highest preference will be appointed president. So this will provide the parties with some form of influence over who to appoint as presiding arbitrator. Finally, I mentioned it before that arbitration might not be an appropriate forum for the smaller corporate disputes because of the costs with arbitration that are very expensive compared to litigation. However, if managed appropriately and in a time and cost efficient manner, arbitration could also work for these smaller disputes. In this respect, apart from agreeing on expedited timetable, you can consider, and we've listed them here, appointing a sole arbitrator, which obviously is more cost and time efficient because you only have the sole arbitrator that is in the deliberations and that's drafting the award, and there's no discussions with the other arbitrators. Second, you can include the statement of claim in the notice of arbitration, since it may reduce the rounds of submissions and the duration of the arbitration. The third option is to immediately file your statement of claim after constitution of the tribunal instead of waiting for 2-3 months drafting it. So make sure that you have the statement of claim prepared and file it instantly. That will immediately shorten the timelines. And fourth, you can agree with the other party not to have a document production phase, not having witness or expert evidence, or not even having an oral hearing, as these processes obviously take time and cost money and may not be necessary in the more simple, low-value disputes. Yeah. So up until now, we covered points on corporate disputes between private parties and gave you our key considerations in this respect. We'll now briefly discuss investor-state arbitration, which is disputes between a private party and a government, or a government. And our colleagues from the PCA, they will speak to this as well. So the following slides only provide a summary of the key points that are relevant in investor-state arbitration. In short, investor-state arbitration serves a particular need for foreign investors, namely the need to resolve disputes in a neutral forum. Instead of at the courts of the host state, the dispute is settled through arbitration at an unbiased forum. Investment arbitration as a dispute settlement mechanism is often provided for in investment treaties that seek to attract foreign investment to a particular country. In most of those treaties, states agree in advance to arbitrate disputes with foreign investors. So they agree in advance to go to arbitration instead of the local courts. And these investment agreements, these investment treaties agreed on by states, they typically grant 3 categories of protection to foreign investors. First is the right to be treated in accordance with fair and equitable treatment standards. And these standards are included in most of the investment treaties that you will see. There can be a violation of the FAT standard where the host state, for example, acted arbitrarily, not in accordance with due process, or violated the investors' legitimate expectations. Second, the principle of non-discrimination of foreign investors and investments in host nations is a basic protection. It generally provides guarantees against discrimination at two levels. First, it ensures that foreign investors will be treated equally to domestic investors. And second, that foreign investors from country A will be treated equally to foreign investors from country B, C, D, and E. Third, and finally, investors are protected against expropriation, which is discussed in the next slide in a slightly bit more detail. Expropriation is, roughly speaking, the taking of property belonging to a foreign investor by the state. There's a distinction to be made between direct expropriation and indirect expropriation. And direct expropriation entails basically the classic cases of expropriations, which is tangible or intangible property of an investor taken by the government by taking administrative or legislative action. For example, governmental authorities might take over a mine, an oil block, or a factory and take it from the investor and start running it themselves. The central and crucial element there is that the property is taken by the state authorities. It's a little bit different for indirect expropriation in that the investor's ownership remains unaffected, and it may continue to keep full control of the property, of the mine, of the oil and gas field, and whatever property it is. But the acts of the government cause the investment to no longer have any economic value. For example, it concerns the unjustified revocation of necessary permits for a given company to operate, or a change in law pursuant to which the business model of a company completely falls away. There's no more business to be pursued. I think we're running out of time, so I will skip this case example, which discusses the FAT norm, and I think it will be perhaps further discussed during the panel. That's our presentation. Thank you.
Thank you, Tom. So far, we received so many questions for you. Okay, you can come back and answer at your place. Trong bây giờ là có hơn 500 người tham dự online và tôi cũng nhận được rất là nhiều câu hỏi, đặc biệt là những cái câu hỏi liên quan đến công ty, bảo vệ cổ đông nhỏ, tranh chấp giữa cổ đông và người điều hành. Thì cái phần này tôi nghĩ là cái phần đang được sự quan tâm rất lớn của các người tham dự. Tuy nhiên cái phần này những cái câu hỏi cho phần này chúng ta sẽ tập trung vào cái phần thảo luận cuối để chia sẻ, và đây là một cái phần khá là hot. Vào lúc này thì chúng ta chuyển sang phần Q&A question. Thì có cái câu hỏi đầu tiên là cho anh Tom, cho phép tôi hỏi anh Tom bằng tiếng Anh. So the question for you, Tom, you mentioned 4 forums above, okay? And what would you recommend, highly recommend, VIAC, CIAC, or any? And the second one, okay, hard question, right? The second issue is, governing laws. Okay, the parties often negotiate very hard on governing law. So in your view, which one you recommend and how to solve the issues in negotiation with regard to governing laws in SPA?
Thank you. Yeah, that's an interesting question on which forum I prefer personally. I think that depends on a lot of factors. Obviously, it's a very lawyerly answer, but it depends on a lot of circumstances of the particular dispute involved, right? I mean, if you are looking to enforce an award in Vietnam, and you know that the counterparty has assets in Vietnam, as we discussed, VIAC is a perfect option there because you can straight away go to enforcement of the award in Vietnam against assets of your counterparty. If you, for example, want to enforce in Europe, then ICC might be a more appropriate forum because it's more known to foreign parties that you're contracting with. They might be more known, they might know ICC better in that region. So it depends on the region, I'd say, where you're looking for enforcement, and also what type of dispute you're dealing with. For example, VIAC has a lot of experience in construction disputes in the region, so you might prefer VIAC for certain disputes, but it really depends on the circumstances.
Thank you, Tom. And you know, the second question for Thương, and I'm gonna leave the microphone for audiences over here if you have any question. The question for Thương is, I'm gonna read it in Vietnamese. Thỏa thuận cổ đông có được công nhận tại Việt Nam không? Thỏa thuận cổ đông được nhìn nhận điều chỉnh theo luật dân sự hay luật doanh nghiệp? Trong thỏa thuận cổ đông, giới hạn quyền rút vốn của cổ đông, ví dụ như không được rút vốn sau 5 năm thì có bị coi là trái luật và bị cấm hay không? This question for Thương, but I also want, you know, Tom and Albert to share your perspective from, you know, foreign laws perspective, Singaporean, etc. Whether or not, you know, the shareholder agreement is lawful, and if lawful, then would it be, you know, prevailing compared to the article of association in your jurisdiction? And I return the microphone for Thương.
I think that this is a very interesting question. From my experience, usually the article of association normally reflect the agreement of the party under the shareholder agreement, which is concluded concurrent with the share and purchase, the SPA. So usually there's not much difference between these two agreements. However, under the laws of Vietnam, there is no clear mechanism that governing the shareholder agreement and its position in comparison to the enterprise laws, where the shareholder agreement may prevail the laws, the enterprise laws. But in my personal view, that the shareholder agreement may govern the course of conduct between the party under the agreement. Nevertheless, where there is any contraries or conflicting between the laws on enterprise and the shareholder agreement, the court or the arbitration may take the view that the law on enterprise should prevail, because the law on enterprise, that is the highest legal document now that governing the rights and obligations of the shareholders or the members of the company. So I think that is not where there is a dispute regarding the validities of the shareholder agreement. That is a very tough dispute for not only the lawyer but also for the party involved in this agreement. And also there is another issue that usually the party provide in the shareholder agreement, that whether there is any contradictory agreement between provision under the shareholder agreement and the applicable law, and under the applicable law which render those agreements to be invalid, then it will be replaced by a new provision that will be consistent with the law, and it would not contradict or it would not cause the other agreement to be provisions under the agreement to be invalid.
Thank you very much, Tung, for the question. I think it's a very interesting question and a very important question as well. And I think part of the answer is that in the more sophisticated shareholders agreements, indeed, you'll see the type of clauses that Ms. Tung just referred to, which provide that the shareholders agreement will prevail over any contrary provision in the Articles of Association. I think in practice, you see often that the parties devote a lot of time to negotiating a shareholders agreement and a little bit less time to drafting the Articles of Association. So the negotiations focus often on the shareholders agreement, and that's then seen as the guiding document by the parties. The Articles of Association are seen merely as an implementation. And I think that's also one of the reasons why in arbitration in many jurisdictions, tribunals will give extra consideration to the contents of the shareholders agreement, simply as a factor of the negotiations. The other reason why they do so is that an arbitration is conducted typically under an arbitration clause in the shareholders agreement rather than an arbitration clause in the Articles of Association. So the instrument that is governing as far as the tribunal is concerned is the shareholder agreement. And to the extent the Articles of Association do not comply with the arrangement in the shareholders agreement, and one of the shareholders invokes that as a defense, that might still be a breach of the shareholders agreement. So I think there is a distinction to be made between, on the one hand, the contractual remedy that you see enforced in the context of a shareholders agreement on the one hand, and any corporate law remedies that might be enforced at the court where the relevant company is incorporated, where that might be different. And to the extent one of the shareholders seeks advantage of that by going to the local court, that might in itself then be a breach of the shareholders agreement. So I think from the arbitral perspective, for all of these reasons, generally the shareholders agreement will be governing and guiding and be determinative rather than Articles of Association.
Any questions? Any questions? Tôi thì xin chia sẻ lại thì đây đa phần những người tham dự và cũng là luật sư sẽ có những ý kiến khác nhau, mà luật sư thì thường sẽ có những cái ý kiến khác nhau. Tôi tóm tắt lại cái quan điểm tôi trong cái việc thỏa thuận cổ đông có được công nhận trong một cái corporation thì nó có hai cái tài liệu cho các anh sẽ biết. Thứ nhất là cái common law của association hay là chapter. Cái thứ hai là cái thỏa thuận cổ đông. Thế thì câu hỏi là cái tài liệu nào nó có giá trị hơn tài liệu nào, và cái đấy là cái thỏa thuận cổ đông thì nó được điều chỉnh tại luật dân sự hay là luật doanh nghiệp. Cái câu hỏi này cũng khá là phức tạp. Thì tôi nghĩ rằng là cái tầm của cái association hay là chapter đó thì nó là cái được áp dụng cho toàn bộ doanh nghiệp và cho tất cả các cổ đông, bất kỳ cổ đông nào, kể cả lúc mà anh có tham gia vào cổ đông, anh có biểu quyết hay là không biểu quyết, anh không biểu quyết cho cái chapter đấy, thì cuối cùng ấy, nó đã được thông qua trên 65%, nó vẫn có hiệu lực giá trị thi hành. Còn đối với cái thỏa thuận cổ đông ấy, tôi nghĩ rằng là thứ nhất là nó là thỏa thuận của một số cổ đông hoặc một nhóm cổ đông, thì nó sẽ có giá trị ràng buộc đối với một số cổ đông, một nhóm cổ đông, và nó không có giá trị ràng buộc đối với doanh nghiệp hay là tất cả các cổ đông mà không tham gia cái thỏa thuận cổ đông. Còn cái câu hỏi thứ hai đó là nó được áp dụng bởi luật doanh nghiệp hay là luật dân sự, thì tôi nghĩ rằng là thứ nhất là theo quan điểm của tôi thì cái nền tảng căn bản nhất của thỏa thuận là luật dân sự. Luật dân sự nó cho có cái quyền là quyền tự do kết ước, các bên có quyền kết ước, có quyền thỏa thuận, nhưng mà điều đó không có nghĩa rằng là luật doanh nghiệp không chi phối. Bởi vì nếu mà cái thỏa thuận cổ đông nó trái với luật doanh nghiệp hoặc các luật khác thì nó cũng vẫn có thể bị coi là vô hiệu. Thì đấy là cái phần của tôi trả lời. Cái phần thứ hai là thỏa thuận giới hạn quyền rút vốn của cổ đông, ví dụ như không được rút vốn sau 5 năm, thì tôi nghĩ rằng là cái thỏa thuận này là hoàn toàn có thể chấp nhận được. Bởi vì cái đã là thỏa thuận với nhau, 5 năm hay 10 năm họ thỏa thuận với nhau, nhưng mà nếu mà họ không thực hiện hay là một cái cổ đông nào đấy không thực hiện thì là sẽ bị vi phạm. Thì đó là cái phần tôi trả lời cho có thêm cái phần của sư Cương vừa trình bày. Xin anh chị em nào có cái câu hỏi nào khác không? Hay là có ý kiến nào khác? Cái câu hỏi kế đến là xin cho hỏi giá trị pháp lý của biên bản ghi nhớ trong quá trình mua bán doanh nghiệp M&A. Liệu có thể tiếp cận rằng biên bản ghi nhớ chưa ràng buộc các bên về giao dịch mua bán, nhưng để chuẩn bị cho việc thực hiện giao dịch được hứa hẹn trong biên bản ghi nhớ, các bên đã phát sinh số chi phí, các phí tổn liên quan, và khi mà thực hiện giao dịch không được thì có thể yêu cầu khiếu nại và đòi các chi phí này hay không trong các biên bản ghi nhớ. So the question over here is, the MOUs, sometimes non-binding MOUs in M&A transaction, and whether or not the parties can take legal actions if the other parties act in bad faith, not comply with what they agreed in the MOUs, non-binding MOUs, to sue for costs and damages related to the transaction. What is your view on this?
I think it's a very important question, and certainly for people negotiating more complex transactions, you see that happen. And I think this two explain that very well. There's a staged approach where parties first engage in an MOU and agree basically to negotiate. I think, as you said, Mr. Toon, there are various options. One can agree that the document is binding or non-binding, but these types of agreements are generally upheld by tribunals. So where the agreement is that the MOU will not be binding, it's generally not something that can be enforced, because tribunals recognize that there is a situation where the parties did not wish to be bound in that situation. Where they have agreed to be bound, I think one of the very important considerations in the MOU is what type of losses can one claim in the event that the transaction doesn't proceed or one of the parties doesn't negotiate in good faith following the MOU. And there are two different types of arrangements that one can foresee. On the one hand, you could say what has been lost, basically the cost of the negotiation and the due diligence efforts, time and perhaps expenses of advisors in that context. But a more extreme type of claim would be to say there has been an opportunity lost to make a profit of the transaction. And so this, I think, is one of the most important clauses in any MOU to define what type of losses one can claim in the event that the MOU is breached, because this may have very significant financial repercussions, particularly where an MOU already provides some of the basic parameters of the transaction, such as rough contours of the consideration, the parameter, the type of target that is being involved. So I think this is indeed a very important consideration that one should take into account.
Câu hỏi kế tiếp, anh chị có câu hỏi nào không ạ? Anh Vũ có câu hỏi gì không? Câu hỏi kế tiếp là cho chị Thương, trong cái trường hợp mà SP đã được ký nhưng mà không phải là vi phạm, nhưng mà có nghĩa là các một bên trong SPA không thực hiện nghĩa vụ, chẳng hạn như là không thực hiện nghĩa vụ mua cổ phần, thì cái remedies nào, những cái bước nào mà bên không bị vi phạm có thể tiến hành để mà đòi cái quyền lợi của mình? So you got the English translation.
Oh, sorry. Good question. So for this question, I understand that the FPA is already concluded with the party, which said the obligation, like pre-closing obligation, is going to be fulfilled by both of the parties, but either like the buyer refused to
perform,
or the seller refused to fund. So whether it may constitute the so what is the remedy? So what is the remedy available for the
in this case?
like there's normally provisions on the record. So, under the law statement or any arbitration, I think that there is a provision for the remedy to bring out the damage, the loss, or to require or to force the breach party to specifically perform the obligation to respect their agreement. So they assess the remedy available for the parties under like to perform or penalty or compensation for damage loss. And under the FTA, there's also provisions on the breakup fee that either the party walk away from the deal without which is not caused by the other party, like failure to perform or any reason that attributable to the other party, then those remedies are available to them.
So, Tom and Albert, in your views, can the parties in the SPA take legal action to force, let's say, the buyers or the sellers, to perform the obligation, the purchasing performance, okay? And can arbitrators declare damages and cost like legal fees, etc., for the deal like this? The deal is not a breach any clause of the SPA, but non-performance. Signed, but refused to perform.
I think this is a very important question, and in part dependent on the governing law of the contract. I think, as we know, there are certain jurisdictions, particularly common law jurisdictions, that take a view that damages are generally preferred over specific performance, which is the type of remedy I think you were alluding to when saying, can the party that is unwilling to comply with the agreement, can it be forced to take off the shares? Can the buyer be forced to do the transaction? So I think that's one consideration. The second consideration is more one of strategy, and that relates to, as a seller in this particular situation, what type of remedy do you want to seek in order to get the result you want to achieve? Many arbitration rules these days offer a very quick type of relief that can force a buyer to take on the shares, and assuming that the governing law allows specific performance, that can be a helpful remedy. At the same time, it can also be a free option for the buyer in a way, because in a very short type of procedure, the buyer will understand whether it has to comply, whether it has an obligation to close the transaction. What we have seen in many cases is that rather than asking for specific performance, a claim for damages is much more fearful or threatening from the perspective of the buyer, because that type of claim will be resolved generally in arbitration on the merits, which may take 1 to 2 years to resolve. There's no quick answer on the issue whether the buyer has to close or not. And if the buyer has failed to close, ultimately the tribunal will award damages for the lost profit on the transaction in many cases, unless that's excluded. So this is a type of remedy that is much more powerful, in my view, often as a means to get the buyer to close the transaction, because a quick remedy of trying to force specific performance might sound good, but is at the same time also a free option for the buyer to just wait and see what the tribunal tells it to do, and then comply if it has to buy, or not comply if the seller loses the case. So this, I think, involves quite a lengthy answer, but it involves both considerations of strategy and governing law.
Thank you. The last question for Mr. Dương and Ms. Hằng of VIAC, okay? Before we take break. Xin mời bác.
Cảm ơn anh cho người dẫn dắt chương trình rất là có tâm. Nên tôi thấy có một cái trường hợp như thế này trong thực tế là khi em ấy thì hai ban giám đốc đã phải làm việc rất là chu đáo, rồi đưa ra rất nhiều những cái hoạch định rất là nghiêm trình để thống nhất, đưa vào những cái thỏa thuận rất đàng hoàng. Thì trong đó thì còn có đưa ra bàn ở đại hội đồng nữa của các bên. Nhưng mà trong thực tế thì những cái viễn cảnh một thời gian sau đó thì ít khi nó được như là những cái thuyết trình trước đó lắm anh ạ. Rồi trong ban giám đốc cũng có thế nào cũng sẽ có bên này bên kia, mà khi nó đạt được như cái bức tranh vẽ ra ấy thì ok, nhưng mà nếu có vấn đề thì rất là khó xử, rồi nó lan ra cả những người viên chức ở bên trong nữa, những người có cổ đông, có cổ phần ở đấy anh ạ. Thế thì tôi xin hỏi là cái thực tế ấy ở các nước châu Âu, ở các nước bạn của chúng ta ấy, nó có hay diễn ra không? Trong trường hợp bức tranh được vẽ ra không đẹp như là thực tế nó không đẹp như bức tranh vẽ ra. Và thực tế ở chỗ chúng tôi trong nội bộ cũng rất khó xử. Thế thì các bạn ở bên kia họ thường giải quyết cái vụ này như thế nào? Hay là tổ chức một cái party nào đó xong rồi xin lỗi mà vài câu là xong?
Cảm ơn
Xin
bác.
cảm ơn.
Thưa bác tên là gì ạ?
Tôi tên là Nam ạ.
Bác Nam ạ.
Dạ.
Vâng, bác Nam, cảm ơn bác Nam. Thế bác Nam cho cháu tóm tắt lại cái câu hỏi của bác để cháu hiểu có đúng không ạ? Thứ nhất ấy, là khi mà một bên bán hoặc bên mua hoặc là trong nội bộ doanh nghiệp lúc mà trình bày cái giao dịch hoặc là làm giao dịch thì trình bày rất là hay, đúng không ạ? Nhưng mà đến khi mà thực tế thì nó không phải như vậy. Một thời gian sau thì nó không phải như vậy, đúng không ạ? Thế thì cái câu hỏi của bác đó là cho các anh Tom và Albert là cái chuyện đó nó có xảy ra phổ biến ở nước ngoài hay không ạ? Và có ở nước ngoài hay không ạ? Thì cháu sẽ để cho các anh trả lời các bác trước, rồi cháu sẽ chia sẻ cái lăng kính của cháu trong cái giao dịch.
Và thường họ xử lý vụ này như thế nào? Những cái việc
thường là sẽ xử lý vụ này như thế nào? So you got the question? You got the question? Okay. Mr. Nam.
I think this is a very good question, very important question, and a question that is at the core of many corporate and M&A disputes indeed. That is, there's a disappointment over the target company that was acquired. It looked all great when the contract was signed, and then it turns out it's not so great after all. And I think your question probably is the essence of what many corporate disputes can be reduced to ultimately. And I think in contractual practice, there are several mechanisms that have developed to address just this type of issue. And I think Ms. Tung alluded to a number of them in her presentation. I think the most important two are a variable consideration that is dependent on the performance of the target, which is in technical terms often called an earn-out provision. And the other one is indemnities and warranties, which was also alluded by Ms. Tung very helpfully in her presentation, which warrant a certain state of the business. Now, the complexity with this is that I think in most international M&A practice, forecasts or financial performance are very rarely guaranteed. So that is something you see less common directly on the actual performance, but you do see it on fundamental aspects of the business. For instance, whether certain licenses in a particular country are operable, whether the certain non-competes are complied with and the like. So I think all of these are ways to reduce the risk on the part of the buyer, but I think it's a very good and important question you're raising.
Thank you, Albert. Thưa bác Nam là trong các giao dịch thương mại hoặc là những giao dịch SPA thì thông thường là các luật sư họ sẽ phải chuẩn bị rất kỹ để yêu cầu các bên là thứ nhất là full disclosure, có nghĩa là phải tiết lộ toàn bộ, và sau đó là cái draft of guarantees, có nghĩa là các bên phải có những cái thỏa thuận là phải trung thực, còn nếu mà không trung thực thì sau đấy là sẽ có thể là cái giao dịch đó nó sẽ xảy ra tranh chấp. Còn lúc mà giải quyết tranh chấp đó như thế nào và remedy như thế nào là phải tùy từng hoàn cảnh. Do cái thời hạn nó có giới hạn thì đây là cái câu hỏi cuối cùng để đặt cho chị Hằng và anh Dương trả lời trước khi chúng ta nghỉ giải lao khoảng 5-10 phút. Câu hỏi là hợp đồng mua bán cổ phần thường tương đối dây dưa kéo dài trên thực tế. Việc các bên có thể cần thương lượng để điều chỉnh giá khi có sự thay đổi trong các thông tin của công ty được mua lại. Thực tế khó tìm được đâu rõ ràng là ngày quyền lợi và lợi ích bị xâm phạm nhằm phục vụ việc tính thời hiệu. Vậy liệu chúng tôi có thể khuyến nghị khách hàng khởi kiện tại VIAC sớm để giữ thời hiệu, sau đó xin tạm dừng để tiếp tục thương lượng với nhau được không? Có rủi ro nào không? Có lẽ cái câu hỏi này chị Hằng với lại anh Dương là trả lời là phù hợp nhất. Hoặc là khởi kiện tại VIAC lấy ngày.
Dạ vâng ạ. Thì cảm ơn câu hỏi của khán giả. Thì được sự phân công của Tổng Thư ký thì tôi cũng xin phép có một cái trả lời ngắn gọn như thế này ạ. Thì trước hết là vấn đề thời hiệu khởi kiện. Thì hiện nay thì được quy định rất là rõ ở trong Bộ luật dân sự này, rồi trong luật trọng tài thương mại cũng có nhắc đến rồi. Và khi mà đúng là các bên trong quá trình mà nếu mà đã thấy là có thể có khả năng phát sinh tranh chấp thì vấn đề về việc là chúng ta phải xem là liệu thời hiệu có sắp hết rồi hay không thì là điều rất là quan trọng. Thế còn về cái ý tưởng của luật sư rằng là liệu có nên khuyến nghị khách hàng là khởi kiện để giữ thời hiệu và sau đó thì đề xuất tạm dừng, đúng không ạ? Thì tôi xin trả lời ngắn gọn như này ạ. Trong tố tụng trọng tài thì thực tiễn tại VIAC thì cũng có những cái trường hợp rằng là các bên sau khi khởi kiện xong thì có đề nghị với hội đồng trọng tài là xin phép tạm dừng tố tụng một thời gian để cho các bên có thể là thương lượng hòa giải với nhau. Thế thì tuy nhiên thì cần phải lưu ý rằng là cái việc mà đề xuất này thì phải đến từ cả hai phía cơ ạ. Chứ không thể nào mà có một bên cứ liên tục. Một khi đã khởi kiện rồi thì chắc là các anh chị cũng biết là khi mà đã khởi kiện rồi, thủ tục tố tụng bắt đầu rồi thì tất cả quyền và nghĩa vụ các bên trong tố tụng sẽ đúng với cái quy tắc của tố tụng và cũng như là luật trọng tài điều chỉnh cái thủ tục trọng tài đó. Ở trong trọng tài thì người ta vẫn nói là the train is leaving the station, tức là tàu đã xuất phát rồi, nó không thể dừng lại nữa. Các quyền và nghĩa vụ của các bên là đã được xét sẵn rồi. Thế thì bây giờ nếu như một bên cứ mong muốn, chỉ có một bên thôi, cứ mong muốn cái quá trình nó phải dài ra, nó cứ trì hoãn như vậy thì là không hợp lý. Bởi vì một cái đặc điểm của tố tụng trọng tài là còn phải nhanh gọn nữa cơ. Thế nên là cũng xin lưu ý với luật sư với cái ý tưởng vừa rồi thì chắc là nó sẽ chỉ khả thi nếu như mà luật sư thấy rằng là cái việc mà cả hai bên cùng đề nghị hội đồng trọng tài tạm dừng tố tụng trọng tài để cho các bên thương lượng thì sẽ là hợp lý hơn và an toàn hơn rất nhiều đấy ạ. Còn nếu như mà mình không làm được cái đó thì cá nhân tôi là với tư cách là thư ký tại trung tâm thì khuyến nghị luật sư là chắc là đấy chưa phải là phương án hay. Dạ. Cảm ơn ạ.
Xin cảm ơn chị Hằng. Xin mời các anh chị nghỉ giải lao khoảng 5-10 phút. Xin mời các anh chị.